Hello, everyone. Thank you. Good morning, Hong Kong time, and also good evening, US time. Thank you all for being here. I'm Cindy from Marketing and Event Management Department at Hong Kong U Technology Transfer Office. It's very delighted to have Dr. Feng here. And today we are going to have Dr. Feng here, who is a partner at Finnegan's Washington, DC office. During this 1 hour session, she's going to talk about the global patent application process and patentability standards, duty of candor, and hot topics in the US patent law, such as patent eligibility. She holds BS and MS degrees from the Peking University and PhD and JD degrees from the University of Utah. And Dr. Feng is very experienced in patent prosecution, opinions, and counseling and due diligence. And to begin with, I'd like to quickly go through the agenda. We will have 45 minutes presentation presented by Dr. Feng, and followed by a 15 minutes Q&A section. So if you have any questions, please just type in the chat box. We will have time for Dr. Feng to pick up some of them and to answer. So let's welcome Dr. Feng.
Thank you, Cindy.
Yes.
Thank you. Thanks for the nice introduction, and thanks for the invitation, Cindy. It's my honor to have this opportunity to present to the professors, students, and other professionals at the University of Hong Kong. So my topic today, as Cindy mentioned, is the life of a patent, a brief introduction to the US patent law. Let me just share my slides. And this is my topic today, life of patent, introduction to US patent law. And this is an outline to my talk today, mainly of four parts. First, a brief introduction to patents. And then I'm going to talk about the events that occur usually during the life of a patent. And then I'm going to talk about several patentability requirements. And at the end, hopefully, I'm going to give to you a few take-home messages. So first, what is a patent? A patent is a government grant of a limited monopoly. So during the term of a patent, other people cannot use, make, or sell your patented invention without your permission. As you can see, here is the cover page of a US patent. This is the patent number. It starts from 10 million now. And this is the date of the patent. It was issued on November 20th, 2018. This patent is about a coronavirus vaccine. And this patent originated from a patent application in Great Britain back in July 2014 from the UK. So as you can see, the inventors and the company back in 2014, they had this foresight. They could see the future that we are in need of a coronavirus vaccine. So as you can see here, it says a United States patent. That means that this patent can only be effective in the United States. This US patent does not protect any rights in other countries. If you want to protect your invention in other countries, you have to go to the patent offices in those countries and obtain a patent there. So a patent is territorial, it's geographical. It depends on whether you file a patent application in a specific country or region. And a patent generally expires 20 years from the filing date. So as you can see here, a PCT application was filed on July 23rd, 2015. So that means this patent will likely expire in 20 years from July 2015, which is going to be 2035, a long time from now. And usually patent applications would be published before it is issued. So as you can see here, the PCT publication was published back in 2016. And here you can see a long list of publications, other publications, and that can be several pages long or could be a few references. These are the references that the Patent Office looked at when the examiner examined your patent application. Okay, now let's look at the compositions of a patent. A patent is mainly composed of two parts. The first part is the specification. It could sometimes include drawings or figures or diagrams. And the second part is the claims. This specification is the body of the patent. It could be a few pages long, dozens of pages, sometimes it's hundreds of pages long. The specification is used to describe the invention. So it gives you the details of what this invention is about, how you make or use the invention. The claims are usually appended to the end of the patent. It is numbered, and this is number 1, claim 1. The claims are the most important part of a patent because the claims define the protected territory of your patent. It's the scope of your invention. When you suspect someone is infringing your patent, you compare the suspected product with your claims to see whether they infringe. It's not a comparison between the product and your specification. The specification is a tool, is a dictionary to understand what the claims mean, but the claims are the language that define the scope of your invention. So as I mentioned earlier, a patent is a grant of a monopoly. So in exchange of this monopoly, you must disclose to the public what your invention is. So a patents will be published even before the patents are granted. The patent applications would be usually published. So that means when you have an idea, if you want to protect the idea by a patent, and your idea will become part of the public domain. If you want to keep your ideas as private, confidential, then you would want to protect your ideas as trade secrets. So patents and trade secrets are sort of like a dichotomy. You cannot protect the same idea by both a patent or a trade secret. It is either or. So what are the considerations? When would you want to patent your idea, and when would you want to keep your idea as a trade secret? So here is a comparison chart of patents and trade secrets. There are pros and cons for both. As you can see, I know there's lots of information here, but as you can see, in general, it is harder and more expensive. It takes a longer time to get a patent because there are specific requirements for a patent protection. You may have to pay a lawyer to write the patent application for you and to respond to patent office actions. And it's generally easier and less expensive to keep something as a trade secret. But the most important consideration is protection from independent discovery. For example, if someone independently came up with your idea, if you have a patent, you can really sue an innocent third party for infringing your patent. But if you only have a trade secret, if someone independently came up with the same idea, you cannot enforce your trade secret against the third party, unless that someone stole or steals the idea from you. But sometimes when you have an idea, you have to be published, or you want it to be published. For example, if you are a professor or a graduate student, you sort of want to publish your ideas to get recognition, to get a grant, or to get a certain reputation. And in those situations, you would want to file a patent to protect your ideas before you publish them. So now let's look at the life of a patent. I'm going to briefly describe the processes related to filing a patent application, the examination processes by patent offices, and the events that usually occur after a patent is granted. So here is a diagram that depicts the general process for global patent rights. As I mentioned earlier, a patent is territorial. If you get a patent in China, it only protects rights in China. So if you want to protect your invention in other countries, you have to go to the foreign countries and file patent applications there. Fortunately, there are treaties among countries in the world that govern how an applicant go about to get patents in other countries. In general, there are two main international treaties about patents. The first one is Patent Cooperation Treaty, abbreviated as a PCT. You might have heard of a PCT before. And another convention is the Paris Convention. There are many, many countries in the world that are members of the Paris Convention, and there are also many, many countries in the world that are part of the PCT. But there are a few member countries or regions that are part of the Paris Convention, but not a member of the PCT. So, for example, Taiwan is a region that is a member of the Paris Convention, but it is not a member in the PCT treaty, which means that if you file a PCT application, that's not going to cover Taiwan. So you have to file a separate application in Taiwan going through the Paris Convention guidelines. So this is a timeline that depicts the main events under the two treaties. For example, at time zero, at 0 month, you file a local patent application, for example, in China, about your ideas. And then within 12 months, you have a choice to file a PCT application to preserve the opportunity to go to other countries later to get a patent. Or you go through the Paris Convention to file the patent application in foreign countries. So usually people would file a PCT application that'll go cover lots of countries. But for those members that are not members of the PCT application, they would file a patent application in those countries or regions, for example, Taiwan. Okay, so look at the first top timeline. This is a PCT timeline. For a PCT application, you have up to 30 months from the very beginning to decide which country you would enter later. So that could be the United States or the European Patent Office, EPO, or Korea or Japan. So that gives you lots of time to think about it. And lots of people like this delay. They think that this delays the cost because during this 18 months, not that many things that could happen. You save lots of money. You can explore your invention and see whether that can be commercialized. That gives you the room to further develop your invention and decide whether you want to pursue it and which countries you go to. So this PCT is generally a slower process that delays the cost and decision making. But for the Paris Convention, at the 12th month mark, you would submit your application to the foreign country patent office. So the patent office in that country would receive your application at that time, and then the patent examination process would start sometime, but under the PCT timeline, only at the, if you choose to do so, you can delay as much as 30 months for the individual patent office in those foreign countries to receive your patent application. So in general, the Paris Convention can be a faster process, and the PCT timeline is slower. So you have the option to choose. In general, pharmaceutical companies or small startups would want to choose a slow process because it takes time to develop their inventions. But for electronic inventions, if you want to get a patent earlier to sue, suspected infringers, you would want to go through a shorter timeline like the Paris Convention. Okay, so now let's look at the patent examination process. So once your patent application is received in a patent office in a foreign country, for example, it's a US patent application for an invention related to a new machine and a process of using that machine. So likely within 10 months or 16 months, you would receive a restriction requirement from the patent office. The patent office doesn't like to do much work. The patent office would likely think that the machine and the process are two separate inventions. They would say that, well, your applications contains two independent inventions. There's a machine and there's a process of using it. And I'm going to just examine one of them. You choose one of them for me to examine. Okay, and then you would reply to that restriction requirement to elect one of them to pursue for protection. For example, you could choose the claims relating to the machine. And then the patent office would issue an office action. Usually it's a rejection. The patent office is going to look at the publications that were published before your earliest filing date. And the patent office would say that, oh, your claims are rejected because this machine was disclosed in this earlier publication, or it's obvious over the publication. And then you can respond to the office action either by claim amendment. You can choose to narrow your claims to carve out the content disclosed in the publication, or you can make arguments to say that, oh, examiner, you are wrong. You misinterpreted the reference, and I'm right. So this office rejection and response can go through several rounds. It can be 2 rounds or 4 rounds, 5 rounds, or 6 rounds. And at the end, if you persuade the patent office examiner, you can get a patent issued. So, but before the patent issues, remember you also had claims that cover the process of using the machine. So before the patent issues, you have the opportunity to file another application. It's called a division application to ask the patent office to examine the claims of the processes. So this is a general process about what would occur typically during the patent examination. Okay, so what happens after you get a patent? So at this point of time, you have a patent that issues. What happens next? Okay, so if you discovered some errors, you still have opportunities to correct those errors. There are 2 types of proceedings that you can use to correct your errors. If this is something that's of a very minor nature, if there's a typographical error, or it's a printing error by the patent office, you can file a simple paper for a certificate of correction to correct those typos or printing errors. But if you have a more serious error, if you want to get a narrow claim to exclude a reference that you newly discovered, or you realize that those claims are too narrow. I want to broaden my claims. So you can file a reissue application to restart the examination process. But there's a catch. If you want to broaden your claims, you have to file the reissue application within 2 years of a patent issuance. Okay, but there's also some risk here. After your patent issues, if your competitor sees it, and if they don't think that this is a strong patent, and if they think that this is a threat for their development and product, they might file a petition to the patent office to invalidate your patent. Okay, so there are some post-grant proceedings in the patent office. They are called inter partes reviews or post-grant reviews, where the patent office can re-examine your patent and decide whether the patent claims are invalidated over the prior art. And if you see someone is infringing your patent, you have the option to file an action in court to sue the defendants for patent infringement. And the defendant has the option to defend themselves in court. They also have the option to come to the patent office here to petition the patent office to re-examine your patent and trying to invalidate your patent. So typically, post-grant proceeding is faster. It usually takes 1.5 years and it's much cheaper. And a lawsuit in a court is usually very slow. It takes like 2 to 3 years, sometimes 4 years. And it's also very costly because there are lots of discovery events in the US litigations. So it's very popular for defendants to come to the patent office to challenge the patent owner's patents. And there are lots of interplays between court infringement actions and the post-grant invalidation proceedings in the US right now. And the invalidation rate at the patent office right now is very high. Almost half or sometimes over half of the patents are invalidated in these proceedings. Okay, now let's look at patent requirements. Okay, so what is required for you to get a patent? So this is at least requirements in the US, but more or less there are similar requirements in other countries. The specific language may be different in different countries, but in principle, they are very similar. So the claim the invention must be novel, which is new, not obvious. They must be described, enabled by the specification, and the subject matter in the patent application must be eligible for patent protection. And also there's a separate requirement that the inventors and agents must fulfill the duty of candor. So I'm going to briefly cover the first 3 items. And for the last 2 items, I'm going to show you some cases. Okay, so let's look at novelty and obviousness. These 2 patentability requirements are related to the prior art. So the analysis has to do with the comparison of the claims versus the prior art. So what is the prior art? Prior art are usually prior publications or sales or other public disclosures before your patent filing date. So the novelty requirement is a threshold requirement. It's very easy to meet. If you have anything new compared to the prior publication or sales, it meets the novelty requirement. But the obviousness requirement is something that's tricky. If you look at office rejections or challenges, there are many arguments about obviousness, because this is something that's very tricky and that's somewhat subjective, right? Because what is obvious? People have different ideas about obviousness. But in general, to respond to an obviousness argument, you would want to present an argument and or evidence that there's no motivation to modify the priority in this way to get to your invention. Okay, and there's also no reasonable expectation of success in modifying the priority in this way. And as you all know, people tend to think that something's obvious if somebody else has already come up with a solution. So to guard against the hindsight in the obviousness analysis, courts usually also consider objective evidence that shows that, well, the invention is actually not obvious if you consider other factors. For example, your invention resulted in unexpected results. That cannot be something obvious if it is unexpected. And if the invention fulfills a long-felt but unmet need, that cannot be, that should not be obvious, because if it's a long-felt and unmet need, if it's obvious, somebody would have already done it. And also commercial success, if it achieves huge commercial success, it should not be obvious, because otherwise somebody else would want to make the money much earlier, right? And also look at failure of others and whether other people questioned whether your this would work, whether your invention would work. So this evidence can be used to showcase that your invention is not obvious. Okay, let's look at another two patentability requirements. So these requirements, written description and the enablement, which are very similar, have to do with the comparison, the analysis of the claims versus the specification. So remember at the earlier of the talk, I said that there are two parts of the patent. There are claims, there are specification. So the specification must provide sufficient detail that a person of ordinary skill in the art, by reading the specification, will believe that the inventor actually invented the invention, and the inventor had possession of the invention. So the specification really is something that persuades a person having ordinary skill in the art to believe that the inventor made the invention. Enablement is slightly different. It also has to do with the specification. The specification must provide sufficient detail to enable a person of ordinary skill in the art to make and use the invention without undue experimentation. Okay, let's look at the last requirement, patent eligibility. So this is an analysis of the claims versus nature. Under Section 101 of the United States Patent Code, there are 4 categories of inventions eligible for patent. They are processes, machines, manufacturers, and compositions of matter. So the patent eligibility right now is one of the most contentious patent issues in the United States. So there are exceptions to this general rule. If your claims are generally about abstract ideas or products of nature or laws of nature or natural phenomenon, you cannot get a patent, because these things should belong to the public, not to a specific person or a company. So let's look at a couple of cases here. And I'm going to show you this case, Araosa versus Sequoia. So this is about an invention that's related to the groundbreaking discovery by Dr. Dennis Low from the Chinese University of Hong Kong. So if you look at the claim here, so the claim is about a method of diagnosing genetic disease in a fetus. So it's detecting paternally inherited nucleic acid of a fetal origin performed on a mother's serum by amplifying the nucleic acid and detecting the presence of the DNA. So the claim is quite general. It's about detecting the DNA to diagnose whether the fetus has a genetic disease. So the court agrees that the discovery is really about the fetal DNA that is present in a mother's blood. And the claims are about methods for detecting fetal DNA by amplifying and analyzing DNA samples from a pregnant woman's blood. But the court says that the existence of fetal DNA in maternal bloodstream is a natural phenomenon. The inventors did not create or alter any of the genetic information encoded in the fetal DNA. And the location of the nucleic acids also existed in nature before the inventors found them. So the court further says that the steps of amplifying and analyzing, those are routine and conventional PCR techniques, and performing the diagnosis is a mental process. So the court concluded that they claimed the subject matter is not eligible for patent, so that patent was invalidated. So let's look at another case. It is somehow related. It is about a method for preparation now. It's about the same general idea, but it's more specific, and it's a different type of a claim. So if you look at the claim language here, it says a method for preparing DNA fraction from a pregnant human female, useful for diagnosing a genetic disease. It has 3 steps. First, extracting DNA sample from the mother, and then producing a fraction of the DNA sample, and then third, analyzing the sample. Look at the step B. Step B is pretty specific. It says that you have to go through a size discrimination, and you selectively remove the DNA fragments that are greater than approximately 500 base pairs. And the court says that the discovery is about cell-free fetal DNA tends to be shorter than the cell-free DNA from the mother. Okay, and the claims are about methods for preparing a fraction of cell-free DNA that is enriched in fetal DNA. So the court concluded that the process steps change the composition of mixture, resulting in a DNA sample that is different from the naturally occurring fraction in the mother's blood. And the process also achieves more than simply observing or detecting the presence of that natural phenomenon. So the court concludes that this patent was eligible for patent protection, and so it stood the scrutiny of Section 101. So if you compare these 2 patents, the earlier patent is quite general. It uses some very general language, amplifying and analyzing, without providing specific conditions. But the second patent is a specific application of this natural phenomenon. It's about preparing a sample that is enriched in the fetal DNA. So right now in the United States, it's very hard to get a diagnosis patents, because diagnosis patents usually involve detecting of some naturally occurring analyte. But if you incorporate specific conditions or limitations in your claims, you might still be able to get a diagnosis patent. Okay, now let me move to the last subtopic, duty of disclosure. Under Section 56 of the patent rules, each individual associated with the filing and prosecution of a patent application has a duty of candor and good faith in dealing with the patent office, which includes a duty to disclose to the office all information to the individual to be material to the patentability. This is a very serious requirement, very, very serious in the United States. A patent may be unenforceable, which means that you cannot enforce your patent. It's invalid. The whole patent is gone. The patent may be unenforceable for inequitable conduct if the applicant fails to disclose material information known to the applicant with the intent to deceive or mislead the patent office. So which are the individuals associated with filing and prosecution? Those can be the inventors, the in-house agents, attorneys, or the TTO professionals, and your outside lawyers who handle your patent applications. And what information? Usually, it's a judgment call, but usually you would want to disclose to the patent office references cited in related patent applications. For example, those references found by foreign patent offices in a foreign counterpart application. And you want to disclose the closing information that were considered by the inventors or the attorneys who during the process of preparing the patent application. And if you made an inconsistent statement in another patent office, you would also want to disclose that with the patent office. So here I want to show you a case to show what transpires in equitable conduct charge. So in this case, a patent was held to be unenforceable due to inequitable conduct for failure to disclose material information. So in this case, this is about an invention relating to an oil recovery system. The application was filed in on August 17th, 2004. So this date is very important. And 1 year before, so this date would be August 17th, 2003. This is a critical date in the US. That means that if you have offered to sell your invention 1 year before your filing date, you can no longer get a patent on that invention. So in this case, okay, 1 year before the filing date, the inventor emailed a customer a sales proposal that was dated July 2003. It was a sales proposal about the oil recovery system. And on August 18th, 2003, one of the inventors visited the customer and presented the July 2003 sales proposal. Look at these events. This is an event that would bar a patent, and this event would not, because this is after that 1 year mark. So during the patent application process here, the inventors talked to their attorneys, and they also self-studied. They learned about this on-sale bar, which means that you cannot get a patent if the invention that you want to get a patent for was offered for sale over 1 year before. So afterwards, during this time, this sales proposal that was dated July 2003 came up. And the inventor filed a first declaration to the patent office saying that this proposal was dated July 2003, but it was actually delivered to the customer on August 18th, 2003. Okay, so that would be after the critical date. And then they realized that this is a mistake. Okay, and then they filed another declaration to the patent office saying that the inventor had forgotten about this email, okay? But in this declaration, they did not correct the misstatement in this declaration. They did not address this email that included a sales proposal to a third party, which is the customer. So those are the factual background in this case. So the court found that the patent was unenforceable due to inequitable conduct for the failure to disclose the sales proposal. And the court said lots of things about the inventor. The inventor really just lost his credibility in court. The court says that the inventor testimony on any topic was of little credible value. That was really harsh. And when questioned, the inventor made inconsistent statements, had some difficulty stay focused, and was argumentative and unclear about facts. But when it comes to those facts that are more beneficial to the inventor, and he would fortuitously remember those things with clarity. So this is in sharp contrast. He would not remember the things that are not beneficial to him, and he would remember clearly those things that are beneficial to him. So the inventor's testimony sounded carefully scripted rather than genuine and generally dismissive or inconsistent with the documentary evidence. So this is what transpired in this case because the inventor acted with bad faith with the patent office and did not act truthfully in court. So the patent was found to be unenforceable due to inequitable conduct. Okay, so with that, I would like to offer a few take-home messages. So in order to meet those patentability requirements, I would recommend that you describe your invention as practical and specific applications, not just use a broad brush, use very broad language to describe your invention. You want to be specific and practical. And you also want to provide concrete and specific examples. Again, more specific and more concrete, not just broadly sweeping the entire territory. And you want to describe your invention in great details, describe how to make it and how to use it so that someone looking at the patent application or patent can know how to make and use your claimed invention. And they can believe that you actually invented the invention. And you also want to explain in the specification why and how the invention is an improvement over the prior art. So nowadays, there are so many publications. You don't just invent something from the vacuum. So there's always a body of publications already out there. So you would want to look at the prior publications and try to explain why your invention is an improvement that is new and not obvious. And of course, you want to draft the claims in layers. You want to have a very broad claims. You want to have medium scoped claims and also very narrow claims. So when you look at all of these patentability requirements, it's always easier to get a narrower claim than a broad claim. And sometimes, especially in litigation, a narrow claim can be very, very effective. A narrow claim that covers your product and that covers a competitor's commercial product is very valuable because it's easier to defend a narrow claim than a broad claim. And then at last, I strongly recommend you to disclose material information that you know to the patent office. You would want to be over-inclusive rather than under-inclusive. In general, the more information, relative information that you provide to the patent office, the more information the patent office would look at, right? And that can make your patent stronger. That can help you to withstand challenges from a third party down the line. So with that, here is a disclaimer. So this presentation have been made for educational purpose. This is not specific legal advice. And with that, I conclude my talk. And if you have any questions, please raise your hand or type your questions in the chat box.
Thank you, Dr. Feng. I can see there are already 2 questions in the chat box.
Okay.
There's one from Lynn, and she asked, she said, thanks, Dr. Feng, for the useful and informative sharing. I have a question. Do I have to apply for the patent after we finish the development of the project? For example, we have an idea and then we develop the platform based on the idea. We will apply for the copyright of this platform after it is finished, but can I apply for patent before the platform development is finished? Many thanks. Hi, Dr. Fromm, can you help to answer this question?
Yes, I think that's a very, very good question. People have these kind of questions all the time. It is also always a balance, like how much data do you want to have before you file a patent application, right? Because you also have competitors. But in general, I think I would generate some data or have some more specifics to be included in the patent application. If you just have a general idea to have very broad terms to describe your invention, those kind of patent applications are not very strong. So even though you can file the patent application in some countries, you can get a patent. For example, in South Africa, they don't even examine your application. They can just, whatever you apply, they just give you a patent. But in order for you to get a valuable patent that withstand challenges after you get a patent, when you talk to a potential licensee, if you want to make a deal, you want your patent to be strong so that you can get a good deal. So I would say that you would want to collect some kind of data to support your platform idea, and before you file a patent application. I know that this is hard to decide, but sometimes I talk to my clients. So just suppose, imagine yourself sitting in court in a litigation, being questioned by the opponent's lawyer, and the jury and the judge are listening to you, and sometimes the judge may ask you a question. And would you be able to provide a reasonable explanation about your invention without like a red face? Would you be able to do that and being credible? I think you would I think from that perspective, if you think that you are happy, you can make yourself believable in that kind of situation, I think you would have enough in that application to support a patent application.
Thank you, Dr. Fong, for your specific answer. And here's another question from Paul. He said, thanks, Dr. Fong. I have one question about the US patent. Does the USPTO offer any fast-track opinion for patent examination? If so, what is the average examination time for fast-track cases? Thank you.
Oh, yes. In the US, there is a fast track option. There are actually several. If you are someone who's a very old age, you can petition to expedite your application. Or if there's something that's really, really important, you can also petition to accelerate it. And there's a third option, which is very popular. If you want to go through this expedited process, that's called track 1. You pay a certain amount of money. It's quite expensive. I think it's $4,800 for a non-small entity to expedite your application. So in that kind of track 1 process, usually if you are able to successfully persuade the examiner, you can get a patent within a year, and sometimes within 6 months or 10 months.
Okay, thank you, Dr. Fong. I saw that Lynn had a follow-up question for you. What if they upgrade if I upgrade this platform later on, how does that affect the patent application? Because I think it's a platform will be always under upgrading to be up to date.
Oh, okay, that's really a very good question, very good follow-up. Let me show you my slide. Okay, let me just hold on. Let me show you, because I want to show you a timeline. It's a very commonly occurring situation. So here, can you see this slide, the timeline for global patent rights? So you have a 0 month. Suppose, Paul, you file application about a preliminary prototype of your platform. So within this, within 12 months, you would have to file a PCT application or application in a foreign country. Within these 12 months, you are allowed to add new information, additional data. So that's sometimes people would do. They file this called like a priority application, and then in the next 12 months, they can file an application with more information and more disclosure. And if I understand that people always improve their inventions, you upgrade your platform. So if you have a more important improvement down the line after the 12-month mark, you would have to start a new timeline, a new application process. But within these 12 months, you can add new things. You can add the upgrade. Is that clear?
I think, yeah, you answered the question well. And here's the last question from Laura. Yeah, as some inventors may not be professional in drafting layered claims, may I ask whether it shall be the inventor or the patent attorneys to draft it in the first place? If it is a patent attorney, what kind of information shall be provided by the inventors in terms of claims? Yeah, that's a question.
Yeah, that's also a very good question. Usually it's the patent attorney that drafts the claims. That's really a patent attorney's job, because the most important part of a patent is the claims. So usually what I would do, I would get some information from the inventor and have a phone call with him or her to try to understand what the invention is about. What is your inventive point? What is your improvement over the prior art? Do you have a progress report or a PPT, a slide deck about your invention? And with that, I would draft layered claims. And to talk to the inventors and ask them to look at the claims. So the claims usually like a starting point for before you draft the specification, because the claims can serve as an outline for the entire application. So after I discuss with the inventors and we finalize the claims, we can then flesh out the specification and try to explain what this invention is about and how to make and use the invention. So that's the process I would go through.
Okay, thank you, Dr. Fong, for your acknowledgeable presentation and also the clear answer for the questions. So I think that's all for today. And last but not least, the recorded version of this webinar will be available. Afterwards, we will upload this recorded version to our social media channels like LinkedIn and Facebook and our TTO's website. And we have organized webinar series on the different topics. So if you are interested in our webinar series, you can follow our LinkedIn, Facebook, and WeChat for more information. Please stay tuned, and I hope to see you next time. So thank you, Dr. Fong, and for all the participants. That's all for today. Thank you. Have a nice day.
Thank you, everyone. Bye-bye.
Bye-bye.